So now we come to the other form of property, community property, which is based on a different view of marriage. Community property treats marriage as a partnership, which decides how the time and labor of each member is best used. So if one of the two decides to stay home and take care of the children and manage the home, freeing up the other to go out into the workplace and to earn money, then the benefits of that arrangement belong equally to both of them. And so the paycheck belongs equally to both of them. It's a more modern view of marriage, I think. And it's kind of interesting that people in America tend to think of the English system, English liberties and the English Enlightenment and so on, as being the more modern one. But in this case, at least the French and the Spanish, the civil rights, civil law parts of Europe, their tradition is the one that seems more in tune with modern ideas about marriage. Okay, the book calls community property community of acquests. What does that mean? It means that the property which the couple earns after marriage is community property. Each spouse has an equal share in assets acquired during the marriage. And, of course, we'll get to this in a bit, either spouse can devise his or her half of the assets by will. So I keep talking here about whether a spouse can leave his share or her share of the assets by will. That's not hugely important. I just want to show how real the spouse's interest is in this property. The fact that the spouse can, the spouse who dies first can leave her share of the property to whomever she wants, shows that she has a really concrete interest in that property. In a separate property regime, the non-earning spouse only has an interest in the property if she survives. If she dies first, she has nothing to leave her beneficiaries. So her interest in the property is contingent on her surviving, which makes it a little less concrete. Property acquired before the marriage is separate property in a community property state. So only property acquired during the marriage is community property. And separate property also applies to property acquired by gift or inheritance, or, and this is a particularly fine point of detail, property acquired as a personal injury recovery. So if I'm run down by a truck and I get a nice juicy tort settlement, that's mine. It doesn't belong to my husband. My husband doesn't acquire a share in it. And there are other little details that we won't go into in such depth. One of them is control of community property during the state. So if the property belongs to both husband and wife, does that mean that they both have to sign off on investments or purchases? That would be troublesome. And so it's resolved differently by the different states. But in the great majority, either one can manage the property. But if it's sold, both must sign off on the sale or transfer of the property. There are some other complications that you don't have to know. They're not on the slide, you don't have to know them, but you might ask yourself, what about the income from separate property, so that you don't lie, so in order that you don't lie awake all night thinking about this, that depends on the state. So in some states, income from separate property remains separate. So if Jared came into the marriage with $1 million in investments and it generated, say, $50,000 a year, that's all his to keep. But in other states, income from separate property is community property. See, it's complicated. You really didn't want to know that. Why do lawyers in New Jersey and New York have to know anything about community property? After all, it's very far away. Well, for one thing, there's the bar exam. That's a good argument. And the other is that couples move between states. So you have to know something about a couple that moves from California to New York or New Jersey, and they're coming with property that's in the form of community property, and you should know what that means. And that brings us to the topic of choice of law rules. So the problems are in both directions. If someone from California moves to New Jersey or someone from New Jersey moves to California, the law of the marital domicile at the time the property was acquired controls the characterization of property as separate or community. So while the couple lives in New Jersey, the property that's acquired is separate property. While that couple lives in California, if they move there, the property that's acquired in California is community property. However, the place where they're living when they die controls the rights of the survivor's rights in the property. So if a New Jersey couple moves to California, they have no community property, all their property is separate, and California has no forced share or elective share. So they're in trouble, and we need a solution to that. We'll get to that shortly. It's true that the law of situs controls problems related to land, but this is one wrinkle too far. So let's pretend that the situs applies to the law of the marital domicile. Moving west to east is the easier case because property acquired in a community property state may be retained as community property when you come to New Jersey. So you just leave it as community property. Each person in the couple is entitled to half, and you don't have to worry about converting it to separate property. In fact, why would you do that? It would not be a good idea. So it could be that a couple who comes to New Jersey late in life holds the bulk of his or her property as community property, and each of them would have an undivided half share of what they acquired in common. Moving from New Jersey to California is more complicated because the couple that arrives in California has its property as separate property. It isn't automatically converted to community property, and California has no elective share. So what to do to protect the survivor? Well, what California does is designate some of that property as quasi-community property. Quasi-community property means that property acquired during the marriage that would have been community property if it had been acquired in California is treated as community property, but only for the protection of the surviving spouse. So it's only to distribute the property to a surviving spouse after the acquiring spouse dies. The non-acquiring spouse has no other rights in the property. He can't devise it if he dies first. So it's a kind of forced share in one half of the deceased's property only to the extent that it was acquired during marriage. Well, I anticipated this in my commentary to the last slide. So quasi-community property means all real or personal property, wherever situated, acquired by either spouse while domiciled elsewhere, which would have been community property if the acquiring spouse had been domiciled in California. This doesn't mean that separate property is converted to community property when you move to California. This is only intended to protect the surviving spouse, to give something in lieu of the forced share or elective share. So the quasi-community property classification treats some separate property like community property, but only on death or divorce. So until death or divorce, the couples each hold their separate property separately. But upon the death of one spouse, the survivor has a 1/2 interest in the decedent's quasi-community property. However, the decedent has no right if he dies before the acquiring spouse, so the community property interest doesn't manifest itself before the death of the acquiring spouse. Complicated? I hope you'll get some clarification in the multiple choice questions. I didn't assign anything on premarital or prenuptial agreements or antenuptial agreements, and you don't have to know it for the exam, but I just thought I'd mention that the parties can opt out of the elective share. So in a premarital agreement or even a postmarital agreement, the parties can agree that they will not seek the elective share when one of them dies. These are, prenuptial agreements are permitted and they are enforced, but if one of the parties claims later that the agreement should not be enforced, that individual must show that the agreement was not voluntary, or the party didn't have independent counsel, or the party did not obtain adequate financial disclosure. So the spouse who was asking for the prenup didn't disclose that he was a multimillionaire. So, for instance, a court has found that an agreement, an antenuptial agreement, was not enforceable where the agreement was presented to the bride on the morning of her wedding and the groom told the bride that there was no time for her to consult a lawyer. This picture is not of a bride who's just been presented with a prenuptial agreement. It's apparently a custom for brides and grooms to write each other's letters, which they read before the wedding, and the bride is crying from happiness. However, the picture will do. With this slide, we turn to a different issue, namely protections for the surviving spouse and children that are granted from the state, in the case of homestead, personal property set aside and family allowance, or by various entitlement programs, Social Security in particular, and by protections that are built into pension plans, which are, after all, the main means of support for many people in their old age. And we have a public interest in guaranteeing that widows or widowers are not left penniless. So starting from the top here, employee pensions are governed by the Employee Retirement Income Security Act, a federal act that gives the spouse of the employee certain survivorship rights in a pension plan. Those are simplest in the case of an annuity. If the pension plan takes the form of an annuity, then the surviving spouse has to be named as the successor annuitant for the remainder of his or her life. If the annuity takes the form of an account, a defined contribution plan, so that the donor builds up savings, then according to the book, the survivor is entitled to everything that's left in the account. I think it's a little more complicated than that because there are various kinds of defined benefit plans, some to which the employer contributes and some to which the employee can contribute independently of the employer, but I'll leave it at that. Social Security is complicated. Well, not really complicated, but we're getting to it on subsequent slides, so I won't talk about it here. The homestead, these are really interesting. The homestead, the personal property, and the personal property set aside were created during the Jacksonian era, which was a populist period, and we're living through another populist period, that sought to protect families from creditors. So the homestead exemption places, quote unquote, the family home in this protected category, so that creditors could not seize the family home. In some states, that literally means the family home. So oddly enough, the homestead exception, which is sounds so homey and frontier-like is of the most extravagant importance in Florida, where the entire family home is protected from creditors. So yet another reason to move to Florida and buy a $6 million house. In a place like New York, there is no homestead exemption as such, and in some states there is a financial cap to the homestead exemption, which is now so antiquated that it amounts to almost nothing, $15,000 or so in some states. The personal property set aside grants the family certain personal items and tools. So again, this goes back to the Jacksonian era, that they would need to get along or to make a living after the breadwinner's death. And in New York, that means personal items up to $20,000. So we're talking here about furniture and clothes and so on. Books, etc., up to $2,500. Interesting, worth buying some books just to get that exemption. A car, and a certain amount of cash. And finally, the family allowance, that is money that's set aside off the top of the estate so that the family can survive the probate process, which could go on for a year. So an interesting thing about the homestead, personal property set aside, and family allowance is that they come off the top of the estate. So even before the creditors have a bite at the estate, we have these provisions for the family. So in terms of satisfying debts from the estate, we first have these family provisions, then we have the rights of the creditors, and then we get to the distribution of the estate under the rules of intestacy or the decedent's probate plan. So it is quite possible, very possible, if you have a small estate, say one of $50,000, that the homestead exemption and the personal property set aside and the family allowance would eat up the entire estate. So during the course of this course, I should have said this earlier, when we're talking about dividing the decedent's estate, we are going to ignore these exemptions because they throw a spanner in the works. So only if I mention them on the exam would you be expected to take them into account. Here is the Social Security arrangement that I was talking about on the last slide. It is very generous because Social Security is generous, or at least generous to the most impoverished. It's meant to keep people off the streets in their old age. By that I mean off, not begging on the streets. I don't mean not playing frisbee or something like that. So not only is the worker entitled to benefits based on his earnings, but so is his spouse and so is his former spouse. So the spouse that was married to the worker at his retirement is entitled to 50% of the worker's Social Security benefits during his life, and 100% of the worker's benefit after the worker's death. So that means that during the worker's life, the worker is drawing 100% of his benefits and the spouse is drawing 50%. So the total income of the family from Social Security is 150%. After the worker's death, the spouse gets 100% of his or her benefits. Or the other option is B, that the spouse would take his or her own Social Security entitlement based on his or her own employment. Now, 50% of the worker's entitlement is often going to be less than 100% of the spouse's own entitlement. So now that both couples are working, it's more likely that both of them would draw down their own Social Security entitlement. Not only is the worker's current spouse entitled to derivative benefits through Social Security, but so is a former spouse. But the former spouse has to have been married to the earner for 10 years or more. That's actually quite a limit because most marriages that end in divorce come to an end much earlier than 10 years in. I think it's more like 5 years in. Anyway, if the former spouse has been married to the earner for 10 years or more, that spouse is entitled to the same as the current spouse. That means 50% of what the worker is entitled to during the worker's life, and after the worker's death, 100% of the worker's benefits. So it is conceivable that after the worker's death, 2 or even 3 spouses and ex-spouses could be drawing 100% of the worker's benefits. But there will also be these other former spouses who get nothing based on his earnings. There are limits. The former, and they're very old-fashioned ones. The former spouse must be unmarried unless the remarriage occurred after age 60, or for a disabled former spouse after age 50, for reasons I have never understood. So if the individual marries again before 60, he or she is also out of luck. So you have to be married for 10 years and not remarried before age 60. I would love to know how many spouses are entitled to this benefit, because it's conceivable that a very large majority of ex-spouses are shut out by these various requirements. The former spouse must not be eligible for an equal or higher benefit based on own earnings. A lot of the loopholes here have been closed in recent years. So it used to be possible for a spouse to draw the worker's earnings for some time while the spouse's own entitlement grew because she wasn't drawing down on it. Those loopholes have been changed, so I'm not even sure that that there's an incentive to take your entitlement based on your ex-spouse instead of your own higher entitlement. This, obviously enough, is an example. You can tell because it says example on it, and I wouldn't be talking to you at all, except that I'm not sure how long the YouTube video will pause on this item unless I do some talking.